Hello and welcome to another edition of For the Record. I'm Sean Murphy. My guest today is Beth Sabilia of Sabilia Law, and we are going to chat a little bit about elder law, one of many things. First time on the show, so welcome to the show, Attorney Sabilia.
Thank you, Sean. Thank you very much.
Is that the proper way to address a lawyer?
It is. Attorney Sabilia
All right.
It's fine. Beth is fine, too.
Beth is fine, too? We're friends now. Elder law, for those who aren't familiar with it, what is it?
Elder law is a term that's being used more generically now than it ever used to be. It has to do with the aging of the baby boomers. You see these kind of flyers in your local newspaper, come to an elder law planning meeting at your local Holiday Inn. It's a general rubric to talk about, okay, when I get older and I may or may not have my faculties, who's going to take care of me? How am I going to manage my assets? And ultimately, if I'm unable to manage my assets, who's going to do that for me?
Now, does that become more of an issue when you have a lot of family that might be vying for position, or does it make more sense if you don't have much of a family at all, or both?
Both, actually. Yeah. When you have no one, let's start with the one situation, the latter of the two. When you have no family whatsoever, the types of considerations that someone with children would make are vastly different for, say, a widow who is in her mid-80s and only has nieces and nephews, none of whom are local.
Right.
Who does she trust? Who does she call? What happens if she falls? Who's going to be there for her? Things like going to the bank can be insurmountable for people that are all alone.
Yeah. Especially if they have physical disabilities where they can't really get out, right?
Yes, that's correct. And then also there are a lot of singletons that are very active at 85, 88, and they're out there and they're having a blast thinking nothing can ever happen to me.
And it can.
And it certainly can.
Right.
It certainly can. So
God bless those types. So,
I tell everybody, if you can, do it.
Yeah.
If you can, do it. Yeah, that's what I tell people. My position is nobody's entitled to an inheritance. If the person coming to me has worked for their assets, is concerned about holding on to those assets for later care, my position is nobody's entitled to an inheritance. If you can do it with careful planning, then that's what you should do, if that's your goal. On the other hand, you shouldn't impoverish yourself to the point that you are left with nothing and kind of at the mercy of others that you've transferred assets to.
Is there still such a thing as, it's an old-fashioned view in my mind, but the reading of the will where the family gathers together and there's an attorney or somebody of the estate just kind of, well, Joseph, you got the antique vase or something like that?
Some attorneys still do a reading of the will. Mm-hmm. In my practice, I try to encourage people to discuss their wills with their loved ones and the people that they're leaving behind. I also ask them to take a look at their wills periodically. When a major life event occurs, when there's been an asset change, for instance, you sell your home and you move into an apartment, if you've become a widow or a widower, if there's been a divorce in the family, all of these things should trigger a review of the will. I can't tell you how many people have said to me, now they're 70, these are the boomers, in their 70s saying, I guess now that I'm a grandparent, I don't really need to name a guardian for my kids anymore. I should take a look at that will. It's 30 years old.
Right.
So
you probably should have looked at it a little sooner.
Exactly. I always encourage people to, where possible, be open. Where possible, discuss issues. Where possible, discuss assets. Full disclosure is always better than disclosure from the grave or people running around trying to find out what you wanted or trying to interpret from Aunt Gladys's statement 3 scotches in on Thanksgiving Day saying, don't hook me up to any machines, that kind of thing.
Is the world getting older?
Yes.
It is.
Yeah. My grandmother's 97. I remember her mother was, luckily for me, was in her 90s when she passed away. I'm meeting more and more of my grandmother's contemporaries. We have more centenarians than we've ever had, people over 100.
Wow.
Than we've ever had before. We used to have something, this is a ridiculous rule in law school, but it used to be the fertile octogenarian rule. If an 80-year-old lady could have a baby, you had to plan for it. Fertile octogenarian.
Is that possible?
Typically not. I mean, hey, Sean, who knows? Medical science is
Which is
moving.
exactly why all these people, these centennials or whatever they are, these people are living longer. Part of that is because of advancements in medicine.
Correct.
But it also means that you have to plan better because people are living longer.
When I talk to clients about longevity, I talk about not necessarily quantity of life, but quality of life.
Absolutely.
If you can combine the two, that's terrific. That's ideal for all of us. We want a great life as long as possible. But sometimes that isn't possible. So then the question becomes, how do you make the remaining time that you have really good quality, however you define that, whether it be traveling, downsizing, not leaving your kids or your nieces and nephews with a 6-bedroom colonial to clean out, or for you to clean every day. So we do
Oh,
talk.
I got to do that?
Yeah. So we do talk a lot about quality of life and try and take an assessment of, is this where you want to be in 5, 10, 15 years? And it's a tough discussion with people that are in their 60s or 70s because they can't find themselves at 85 or 90, but they will be. And a lot of them, the majority, will make it longer than they thought they would have, in part because of advancements in medicine,
Right.
which raises other issues.
Right. Yeah, things like, off the top of my head, like Social Security, which really wasn't designed for people to maybe necessarily live as long as they are living. Hence, will there be any funding left by the time we, are eligible for it?
Right,
Little
right.
things like that.
Well, people that are 50s and under, you've got a plan that there'll be no Social Security, and that's a hard. When you look at most 40-year-olds and you ask 40 to 50, what have you got saved? They're in the throes of raising their children.
Living paycheck to paycheck.
Living paycheck to paycheck. It's tough. It's tough out there. So a lot of people don't have money put away, and they are counting on that Social Security. So it's a real shift in mindset and hooking them up to the right people I'm not a financial planner. They've got to go talk to somebody about how they're going to increase the quality of life financially. We can do work with what they have on board, but if they're looking to grow or do other investment strategies, that's not typically a role for a lawyer.
Right.
That's typically a role for an investment person.
When you talk about quality of life and things you don't want to leave with your children that they have to take care of, it always gets me thinking about what things in my house am I embarrassed about right now that I want to take care of if I should die tomorrow. You know what I mean? And you got to I got to take care of that. I really got to take the trash out.
Right,
soon,
you got to make a deal with a good friend. If something happens to me,
don't tell anybody anything.
Yeah, can you go pick up the laundry or whatever else is in the house?
How early should someone prepare a will these days?
Anytime there's been a major life change. So, for instance, if you're, let's just talk about what happens if you don't have a will. If you don't have a will, the laws of intestacy govern, which means there's a statute out there that says who gets what. If you have parents, they take. If you have sisters and brothers, they take. If you have a child, they take. It's all in different proportional shares. Different people get different amounts of money.
And they don't have any say in it because
they have no say.
Can they contest it?
Not the laws of intestacy, no. The family, one thing that people don't realize too, this reading of the will that you talked about, you always want to try and honor somebody that's passed away, their wishes. You just always want to try to do that. As a human being, you say, well, this is their last thought, this is their last statement. But at the same time, if there's friction within a family because of that, there's no reason why a family can't sit down and talk about things. Well, Aunt Nellie left you $100,000 and she only left me 90. You can always sit down and talk about these things, and sometimes having a lawyer there can help. The lawyer that drafted the will may know why.
But they could be the ultimate mediator and moderator, to bring the parties together,
What we always try and capture as lawyers is the intent of the person that's sitting in front of us. I would say 99.9% of the time we get it right. That doesn't mean that despite our best advice of talking to your family has been heeded. So the family may be caught unaware. Why did Aunt Nellie leave you 100 and me 90? And sometimes the drafter can say, oh, remember that $10,000 loan when you were 20 that you never paid back? That's why.
Right, and
Or,
then the
you know,
person's like,
oh,
oh,
I
okay.
get it.
Yeah.
Or I help pay for so and so's school, so she doesn't need as much as Bob, who I wasn't able to help at that time.
Yeah.
People do that kind of horse trading all the time when they're looking at their estate assets and to whom they want to leave those to.
Do you find there's in more cases there's conflict, or most cases agreement, and you don't really have these issues when it comes to, the payouts and the settlements and things like that?
I think it's fair to say that the old adage is true. The more money at stake, the more
Yeah.
fighting you'll see.
And the more relatives are coming out of the woodwork, so to speak.
That's true. I have a term that's called shakedown for
Yeah.
and they just get involved in it. They insert themselves in a will fight just to do it,
Yeah.
to try and shake out some money.
Maybe they haven't been involved with the
person in
yeah.
a long time.
Yeah.
People can be, and a lot of people aren't aware, you can be disinherited. So somebody writing a will can disinherit someone for reasons that are personal and sufficient. If they haven't seen their child in 40 years, despite their best efforts or what have you, it seems logical that that child may not be included at the end, and it'll hurt.
Yeah.
It'll hurt. So if that's the situation, what I try to do is counsel people to put in a paragraph as to why. Don't leave it a mystery or leave a letter after the fact. I always ask people not to reach out and slap someone from the grave. Like I said, open, honest communication is the best way to go. Sometimes that makes people feel at risk, though. We also have to look at the flip side. It's my money. I'll do with it what I want, and it's nobody else's business. That tends to be a defense mechanism, that they don't want to get into these messy discussions. And sometimes using a family attorney can help with those family discussions.
Sometimes it seems one of the biggest bones of contention is questioning whether the person, the will writer, is of sound mind.
Yes.
You know what I mean?
Yeah.
Did she really mean that?
Yeah.
Or how do you deal with that?
Wills, when a will is signed, the term for it is executed. But when it sounds awful, right?
Right,
When a will
yeah.
is executed.
That's why it's called life insurance and not really death insurance.
Right,
you
that's
know?
right. Life insurance is a very useful planning tool, but
Right.
that's outside of a will. A lot of people don't realize that, just as a side note, and something to come back to. When you sit down, what you try and do is capture the intent of the person, and usually the natural bounty of somebody's affection. Sean, you've always been my favorite nephew. You and I have had lunch together for the last 20 years.
Mm-hmm.
That's kind of a natural, then Sean getting 60,000 and another cousin getting 40 isn't so absurd.
Right.
Or another cousin getting nothing and Sean getting all of it. Or another grandchild getting nothing and one grandchild being singled out. There are a whole host of reasons that motivate people. And what we try as lawyers try to do is capture the intent of the testator, the person writing the will. And if we get it right, then the person sits down and signs it. Here, or executes it. Here, when they sign it in front of two witnesses and a notary. The notary is taking, or an attorney in Connecticut also can act as a notary, is taking the oath of the witnesses, not of the person signing the will.
Gotcha. They're the ones that determine if the person signing the will is of sound mind.
Correct.
And then, so you're going through, okay, I
That's
gotcha.
right.
Yeah.
So there's always a discussion with the witnesses and the person that's signing the will. Just kind of a not, do you know what day it is? Do you know who the president is? But usually, my staff I'll use, two of my paralegals or my assistant and a paralegal, we'll sit down and chat with people just so that they're comfortable. I may know somebody for a decade, and Sarah of my office is meeting her for the first time. So she needs to have some conversation with her to be comfortable that she's, firstly, of sound mind. Well, firstly, over the age of 18. Mm-hmm. You have to be over the age of 18 to sign a legally binding contract. If you're under 18, the contract can be voided. Doesn't mean it's always void. It means it's voidable. There are over the age of 18 of sound mind. So, well, I want to stop here. That doesn't mean that somebody with some dementia or periodic senility or the start of Alzheimer's or some other medical diagnosis, schizophrenia, bipolar, something that alters your sense of reality.
Right?
Right, but it doesn't mean that they're not capable of drawing up a will. The question is, does this person know that these are their assets or this is their bundle, kind of. They may not know that it's, this investment account number or that, but do they know that
Regular
these are
people
their
wouldn't know that.
assets, right? And that they're giving them away after death. That's the testamentary intent that we look for. We don't look for somebody that, is equivalent of Stephen Hawking's. We look for the regular person having a sense of what they're doing and why they're doing it. So the why they're doing it is, like I said, we get back to the natural affection and the object of that affection. Sean has been your favorite nephew forever, hasn't he, Mabel? Yeah, Sean takes me so we engage the whole firm to ensure that the party knows what they're doing and that it seems logical. There are times where you have to stop and pause and ask somebody, are you sure this is what you want to do?
That will give us an opportunity to stop and pause right here and take a break. You want to give a website out? And
It's Sabilia Law, www.sabilialaw.com. S as in Sam, A, B as in boy, ILIA, law.com.
we got a graphic up on the screen, too, for people to
Thank
go.
you.
Beth Sabilia from Sabilia Law. We're learning a lot. We've got a lot more to get to, so we'll take a break and come back. I'm Sean Murphy. This is For the Record. Stay right there. Welcome back to For the Record. I'm Sean Murphy. Beth Sabilia from Sabilia Law in New London, Connecticut is joining us, but you've got clients all over the place.
I do.
Flying in from Rome and
I do have one
Berlin.
client that travels quite a bit,
yeah?
but it's not, it's for his industry.
Let's get into some more topics of this conversation. And one subject is pretty hot right now: healthcare.
Yes.
So we'll, in the terms of elder law, healthcare decisions, the living will, stuff like that. What do you want to say about that?
Some people don't know what a living will is. Let's start with that. A living will is a generic term for a set of instructions. The set of instructions are contained in either a healthcare directive or a healthcare directive with a healthcare power of attorney. Unless you put in writing that you want certain things withheld, in the state of Connecticut, there are 4 things that you must write you want withheld. You're leaving it up to the discretion of either a power of attorney or the physicians treating you as to whether or not you're going to receive certain medical care. The triggering event typically in a living will is a statement by your doctor that you're in a permanent vegetative state with no reasonable hope of recovery. Now that's important. Permanent vegetative state with no reasonable hope of recovery. This is a physician making that determination, and typically you'll have more than one physician chiming in. And I've been at end-of-life situations, and it's typically more than one of the doctors chiming in.
I had to deal with that with my own mom.
You did.
And basically the doctors asked me, do you know what your mother's preference would have been? And I said yes. Unfortunately, it's hard for me to be the one to make the call.
Yeah.
I also had the advantage of my entire family, cousins, aunts, all that, were all supportive of whatever decision I decided to do. I could have gone either way.
Right.
And but the doctor said, do you know what her preference would have been? And I said, absolutely. And I made that decision. I had to, which, the big guy upstairs could have made the call for me.
Right.
But I had to do it, and everybody accepted that decision.
How did you feel, though, being the person to make that call?
Horrible.
Yeah.
Horrible.
Yeah.
Horrible.
But you knew because your mother discussed it with you.
Right. I knew what her preference would be, and I think that I would choose the same way. I think a lot of us would, but it was just extremely difficult, emotionally.
Of course it is, which is why it's important and why it's great that your mom talked to you. And probably talked to your cousins and everybody else over the Thanksgiving table.
And a lot of it's in casual conversation. Oh, go, pull the plug.
Right.
I don't want to, and stuff like that too. But she made it pretty clear what her desire would be.
But let's take a step back when things aren't as ideal. When you've got blended families, say. Radio guy, Casey Kaysen, There was a huge fight over what was going to happen with Mr. Kayson's life while he was living.
Yeah, it was,
and it was
all
horrible.
in the media and everything.
It was
too.
horrible.
Yep.
It wasn't as extreme as the Shivo case, which is the one down in Florida that everyone remembers, as to whether the family the husband could disconnect her. But in Connecticut, we allow for, and a lot of jurisdictions in New England allow for the first triggering event to be determined by a doctor. No reasonable hope of recovery. Then the next 4 things that you can withhold if you choose to are CPR, which is, the heart, respiration, breathing, fluids. People don't think fluids are a life-sustaining measure, and it certainly is.
Absolutely.
It certainly is.
It's amazing how lawyers have to learn medical terminology just because of the world that we live in.
Yeah, yeah, it's certainly, and as I said before, I've been at end-of-life situations with clients that don't have anybody to speak for them. And the one question I ask the doctor repeatedly is withholding fluids going to hurt them, right? Because you never want to cause anybody any harm, right? Even if they have that DNR or the living will.
Right.
The other issue that you want to say is make me comfortable.
Right.
Don't take my life, but make me comfortable. So you can decline respiration, feeding tube, fluids, and CPR. Or you can leave it up to your healthcare agent to make those decisions. Or
who's your healthcare agent? Your doctor? Is that what you
no, you would nominate, say, a son or a spouse, or if in the case that somebody might be overwhelmed with that decision, it can be 2 people.
Okay.
Or if you have a spouse that travels a lot and you think, ooh, what happens if, or a child that travels or is in another state in California, what happens if they need to make this decision and Susie's not here, she's flying back? You can have a backup, okay? Ideally, they'd wait for Susie, but sometimes it's not possible when you're dealing with end-of-life situations.
Let's move on to power of attorney. That's another expression that people hear a lot and may not understand exactly what it means.
Sure. A power of attorney is a document that somebody signs, again, that is of sound mind and over 18, that grants to a third party, typically it's a relative but not always, the power to do things on behalf of the person giving the power. So, Sean, if you gave me your power of attorney, I would be known as your attorney in fact. You could say, Beth, I'm way too busy with the show this week. Can you get my mail and pay my bills? So long as I've used that power of attorney to go on your bank account and to have access to your information, if you grant me that ability, I can go ahead and do it for you. If, on the other hand, you've given me a power of attorney and you say, I'm way too busy and I'm out of here for a year, I'm going to Bali for a vacation, take care of everything, that too would allow me to take care of everything for a year, 10 years, 3 months. The power of attorney lasts as long as you, the person granting it, allow. And it can also be modified, so it can deal with real estate or not. It can deal with banking transactions only or not, insurance transactions only or not. There's a whole list of items that the person giving the power can either grant or withhold.
Power of attorney can be abused very easily, can it?
It can, which is why it always makes sense to have a very close and trusting relationship with the person that you're granting the power and somebody that you designate as a third party to review and meet with that person that holds the power of attorney. So, for instance, if you grant your daughter the ability, you go into a nursing home and you want your daughter to pay your bills, it's not a bad idea to ask your daughter to meet with your lawyer, to just go through things about what's allowed and what's not allowed. And then typically what we do is set up a meeting in a number of months to see how things are going with that person that's taken over the authority. But so long as that power of attorney is floating out there, it's good. So, Sean, if you wanted to revoke the power of attorney in my favor, you've come back from Bali, you would have to notify me. And then anything I do after that I'm no longer your power of attorney is on me, and I'm liable. But that doesn't help you once, the account is gone or something.
No, that's
so
the thing,
you really got to be careful and selective about what you do.
I have so much more in my notes here that I wanted to get to, but unfortunately we are out of time. So, but we did learn a lot today, and I think very important stuff, elder law. So we'll have to have you on again.
That's
okay?
great. I'd be happy to.
Beth Sabilia from Sabilia Law. You want to give out the website one more time?
Sabilia Law, SABILIALAW.com.
You can see this show and many others on our YouTube site. Until next time, I'm Sean Murphy. This is For the Record. Take care.